Hi everybody, welcome to Active Self-Protection Extra. Today, I'm going to talk to all of you. This video hopefully will help mostly lawyers, but I'm going to give enough context and background that non-lawyers can be helped as well, and it might be an interesting topic to you. I want to talk about a Daubert challenge to the testimony of an expert witness and how to answer a Daubert challenge for all my attorney friends so that I can send this to attorneys when they ask me to help them for the Daubert challenge that almost certainly will show up when we're going to go to trial. MagTech is the only freedom seed I use on the range. I personally have over 100,000 rounds downrange of MagTech, and it's unbelievably reliable, very accurate, and a great value. Pick some up for your next range trip wherever you shop for range supplies. First, I have to lay a groundwork of what a Daubert challenge is. And I get it. You're an attorney, you're watching this, and you're like, John, I just need to know the basics of it. I'm sorry, I needed to kind of talk about this for non-practitioners as well. And what this is, all right? So I'm going to tell everybody about kind of the background. I'm going to put my glasses on because I'm going to be reading some stuff and, old age gets us all. Here's what a Daubert challenge is, all right? When we, as an expert, when I want to testify in a trial, when an attorney hires me, well, it's a client that hires me, but when an attorney says, yes, John, I want you at trial to explain this particular issue, and to talk about this use of force, this use of usually deadly force, and many times we're going to get challenged by the other side on that, right? And I say that the other side, I generally work for the defense, but I've worked for the prosecution. I have a case that I'm working for the prosecution right now. I'm an educator. I don't pick sides. I am outside of the system, all right? So when that happens, they will almost always challenge it. The other side is going to challenge it because they're like, look, we don't want this guy to testify. And if I was the lawyer on the other side, I would almost certainly file a Daubert challenge, hoping that I could keep this expert out of court, because the easiest way to keep whatever I'm going to say that will damage the other side's case is just to keep me from testifying to begin with. And that's not a personal attack on me. That's just them doing their job and trying to win a case. That's what a lawyer's job is to do. They're adversaries, right? So, what is a Daubert challenge? Well, this comes from a 1993 Supreme Court case of, it's called Daubert, D-A-U-B-E-R-T, versus Merrill Dow Pharmaceutical Company. And basically that case was about expert testimony that was based on basically pseudoscience, that was based on bad data, bad reasoning, bad inferences, wrong logic. And so it was basically crap. And before Daubert, what would happen is that when another side called an expert witness, then the judge would basically say, well, the jury can weigh the weight of that and the other side can discredit the expert testimony, but the jury gets to weigh whether or not this expert's testimony is any good. The challenge with that, of course, is that in technical or scientific environments, that a jury, which is composed of just 12 regular people, probably doesn't have the technical background to evaluate whether this testimony is any good, whether it's actually true or not. They just see this guy or gal who is, testifying, well, they're the expert, so they say so. Before Daubert, they had what they called a Frye standard, which the Frye standard was basically, it's presumable that it's admissible, and then we can suss it out later and the jury can figure out if it's any good. Well, what Daubert said is, nah, man, we can't do that. That we have to kind of have a standard, and that the judge in the case, the trier of law, needs to kind of act as a gatekeeper. And we want that gatekeeper to keep out pseudoscience, to keep out, basically crap conclusions that don't have any kind of basis in reality. And so we want the trial judge to at least gatekeep this a little bit and keep the jury from hearing crap science. That's what it was for. Well, there's actually been three. It's actually a Daubert trilogy is what they call it now, because there was a couple of other cases that got involved. I'm not going to bore you with all the details, because starting there in 93, then trial courts really didn't apply Daubert really well. So they had amended the Federal Rule of Evidence 702, which deals with the testimony of expert witnesses, in 2000. And then trial courts still messed with it and still didn't do a very good job with it. And there was all kinds of kerfuffle about that. And so in December of 2023, they amended the rule again to be more clear on what the standards are. And so that final amendment, December 1st of 2023, which most states have adopted, okay? I don't have the number off the top of my head, but most states follow the federal rule 702. Like in Arizona, for instance, we have the Arizona Rules of Evidence, which are pretty much an identical copy of the federal Rules of Evidence. And we adopted the amendment to Rule 702, which was ratified by the Supreme Court and placed into the federal Rules of Evidence on December 1st, 2023. Arizona adopted it January 1st of 2024. So our standard, and where I live in Arizona, is identical to the federal standard. That's what most states have done. A few have not done that, but it's pretty rare. So let's take a look at what it says. What the Federal Rule of Evidence 702 says is this: a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B, the testimony is based on sufficient facts or data. C, the testimony is the product of reliable principles and methods. And D, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. Whew, words. Remember, laws are not written in English. They're written in lawyer. So let me explain a little bit of these to you, and then we'll talk about how to answer a Daubert challenge and why we would. So an expert witness, this says, gives us what an expert witness is. It is one who is qualified as an expert in a number of ways: by knowledge, skill, experience, training, or education. And they can testify in the form of an opinion or otherwise. The latest update there allows an expert in federal court to give their opinion to the ultimate fact. It says, no, they can give their opinion to the ultimate fact as to whether they believe this is reasonable, as long as the other ones are met. Some states still don't love that, especially in criminal court. So it just kind of depends on the jurisdiction you're in, but I'm going to talk about that a little bit later, okay? So hold on with me on that. So it says here, they may testify if the proponent demonstrates to the court that it's more likely than not. Let's stop there for a minute. So the person who wants to bring an expert in has to demonstrate to the court that these four standards, more likely than not, are met. So this standard here, first of all, it's the person who calls the expert who has to prove this. And they have to prove it more likely than not. So this is what they call the preponderance of the evidence. So it's like 50% plus a skosh. 50%, some people might say 51%, but it's like 50% and a grain of sand that these four things are likely. Okay, so let's figure out what those four are. And I'm going to actually go B, C, D, A, because I think the way that we do these, actually, we should look at them B first, C, D, and then A. So first B, we have to ask, is the testimony that the expert is going to give based on sufficient facts or data? So as an expert, you're always going to ask, what was my opinion based on? Was it based on sufficient facts or data? Now, in scientific issues, I'm not talking about scientific issues, okay? So we're not talking about that in my case. If you're talking about forensic evidence, if you're talking about, scientific issues of material science or whatever, that's not my gig. I'm going to talk about use of force. So what data, what facts did you use? What evidence that's in evidence did you use to come to those conclusions? We'll talk about an expert report here in a minute, but I always list, here's all the data, here's all the evidence that I was given that I used to form my conclusion. So then that way you have a list. Here's all of the evidence and the data that I used for that. So that's the first one. Is this testimony you're about to give based on sufficient facts or data? You can't just go, well, as a general rule, this happens. Because in a court case, of course, the details are what matter. The facts that are in evidence are what matters and how those apply to the law. So do we have sufficient facts or not? C, the testimony is the product of reliable principles and methods. So you can't just say, because I said so. So it kind of under the old Fry standard, if somebody was a recognized expert, well, they're the expert. And so They say so, and so it goes. Not under the Daubert standard. Under the Daubert standard, what principles did you use to come to your conclusions? What was the basis of your conclusions? So, for instance, when we have a case that we say, oh, okay, so here's how human beings perceive. Well, what basis did you come to that conclusion? Here's how long it takes for a decision to be made. Well, how did you come to those conclusions? And so we will cite studies, we'll cite research, peer-reviewed research that says, here's how this goes. Here's why we know that. Here are examples from known data that we can use that give us some examples of how these things go. So did they have good data? And is the testimony the product of reliable principles and methods? Not just some quackery that you did, but is this something somebody else could walk through and get a similar result to you? And then D, is the expert's opinion, does it reflect a reliable application of the principles and methods to the facts? So here's what we did in terms of looking at what the realities are of use of force. So we might be saying things like perception, decision-making. We might be talking about how people see things, how they process data, how long those things take. What a person might look at and say, wait, is it likely that this particular force would cause great bodily harm or death? And how do we know that? What are some of the data from that? And then from that, do we apply that data via a reliable method to the facts at hand? So in a use of force case, what we would say is, here's what we have as far as the evidence. Here are some principles that we have that we understand from research and from actual application of a perception, decision-making, memory, and those things. And then we look at, well, what are the jury instructions say, or what does the black letter law say? What are the standards applied? So the standards, the evidence, the principles, do we put all those together in a reliable way in order to come to a reliable conclusion? Those are our three real standards there. And then if we apply those three standards, the testimony is based on sufficient facts or data, the testimony is the product of reliable principles and methods, and the expert's opinion reflects a reliable application of the principles and methods to the facts of the case, then we go to A, then we say, then all this scientific, technical, or other specialized knowledge, will this, done this way, help the trier of fact? Now, the trier of fact is usually a jury, okay? The trier of fact can be a judge if you choose a bench trial, but usually when I'm involved in these, it's a jury. And so the trier of fact, the jury, to understand the evidence or to determine a fact. So will this help them? More likely or not. If you meet that standard, and it's not a high standard, then it's admissible, and that expert testimony is admissible. Okay, so how do we get this admitted in court? Because what happens all the time is, I see this pretty common. I get hired by a client. The client provides the money. The attorney is the one that I'm talking to all the time. We look at the evidence, and let's just say I write a report for this one. Here's my report. We write the report. I get all the evidence. I usually ask the attorney 4 or 5 more times. I need this evidence. I need that. Do you have this in evidence? Do you have this discovery? I need this too. Given all that, I apply everything else that I know. I write a report. Most recent case that I had, I think my report was 25 pages long. Wrote that report up, sent it to the attorney. Attorney discloses it to the court. Court gives it to the other side. Very often then the other side will want to do a pretrial interview. They basically want to kind of cross-examine me before trial on my report. Sure, no problem. We have that discussion. Then they file a Daubert motion that they say, aha, we want to keep this guy's testimony out of court. Which again, I don't blame them, because again, the best way to, they look at that and they go, oh no, this is going to hurt my case. Let's see if we can keep it out. We can file a Daubert motion because basically we don't like his conclusions. I get it. So then this is what we ask. The Daubert standard has very specific criteria, very specific tests. So here's what I always say, here's how we handle a Daubert challenge. Number one, we point to the very specific test. Is the testimony of the expert based on sufficient facts or data? Is the testimony that this man is going to present, man in this case if it's me, is the product of reliable principles and methods? And is the opinion based on a reliable application of the principles and methods to the facts? If so, then this will help the jury to understand an area that a jury of regular people is not really well versed in, that they need some technical understanding of that. Now, some maybe not, we don't really call this scientific, though we do some scientific type of testing. This is more technical and specialized knowledge. Will this help the trier of fact? More likely than not, yes, so I get to come in all the time. But here's the key to me. The big key here for an attorney, now bringing the attorneys back in, the big key here is, this is why I always ask to write an expert report. It does take hours for me to do that. So that's billable time. And so your client is going to end up paying money. And in a self-defense case, sometimes the attorney's like, well, I don't want to kind of tip my hand about where we're going and how we're going to defend ourselves, so I don't want you to write a report. Listen, in a self-defense case, we're already stipulating to the fact that the client did the actions. We're stipulating to the fact, yeah, I shot that guy, or yeah, I cut that guy with a knife, or how I ran him over with a car, or I however that went. And so, but we're saying, but I had a privilege to do so. I was okay to do so because it was justified, because I was at risk of death or great bodily harm myself. So you've already told them that you're going for a self-defense justification is what you're doing. So writing the report, I don't think tips the hand, but what it does is it allows me as the expert to lay out the facts and data that I used, the reliable principles and methods that we applied, and that the conclusion matches the way that the principles are applied to the facts. So it basically answers the three criteria that comes back. And then will this help the jury? Well, I mean, I think by a preponderance of the evidence, hopefully the judge sees that it does. The report here is key. And here's a couple other things that I think we really want to talk about, because there are still some jurisdictions that, and lawyers will do this, especially I've had prosecutors do this in the past. This man is just trying to, he's just trying to impose upon the providence of the jury. He is just trying to say he believes that it was justified, and that's the jury's job to decide, not his job to decide. If it was reasonable, that's his job to decide. And so what I always say is, I'm not trying to invade the providence of the jury. What I want to testify to is I want to testify to the technical side of this so that the jury understands the standard. I got this piece from Masad Ayub. Masad says, look, if we were in a medical malpractice case, we would need to know, for instance, what was this illness or this problem that the person faced, and then what would a surgeon or a doctor, what would we expect of them? What's the regular standard of care? What would be expected of them to do? And what would a normal, regular doctor, what would they be trained to, and how would they proceed in this? And then this is what the doctor did based upon the evidence that we have. And so is what the doctor did in line with what the standard is for a regular practice of medicine? So that's a technical issue. In these cases, what we're looking for and what we would testify to is things like perception, things like how long did the defendant have to make a decision here, things like what constitutes a threat of great bodily harm. Is this common to put somebody in the hospital if they take this kind of injury? There's those kinds of standards. So when we say, wait a minute, I say all the time, I'm not trying to do that. And in fact, in my reports, I always have a paragraph in my report that says, the ultimate fact and issue is to be determined by the jury. It is their providence to say whether an act was justified or not. What I'm doing is applying the standards, the evidence that we have, the principles that we know about human performance to the standards of the law. And then the other issues here might be issues of what does somebody see? How long does it take them to make a decision? What happens under deadly stress in terms of how many decisions can we make, and other technical parts of those things, and how auditory exclusion works. There can be a number of issues like that. How do we make decisions? And one of these things that we talk about with things like Hick's law, and that's a whole nother issue, but how do we make decisions and we grab a hold of the first and okayest decision according to recognition prime decision making? There's an issue that we see a bunch. So how do we put all those together? So we explain those to the jury according to the standards. So the report there is really key, because what it does is it unlocks those things for the jury so that they can understand it. And I got to help the jury I don't want to be a huge nerd up here. I want to put the cookies on the bottom shelf so that the jury can understand them and apply those principles and those facts to the evidence when they're looking at that to deliberate whether these actions were justified or not. And so I would say, listen, I don't want to testify to that. Or you can ask me at the end if you want to ask me at the end of things based on your training, background, and experience, based on the principles that you've applied, based upon the evidence that you've seen. Is this, was it reasonable that he saw this way? In my opinion, yes, or in my opinion, no. And in most jurisdictions, I can give that. But whether I can or not, I'm okay with that, because what I'm really trying to do is I'm trying to talk about the underlying factors, okay? Here's a way that I like to put it all the time, and I like to talk to juries about this, right? I talk to the other side's attorney about it. I'll talk to judges about it. I always ask this all the time. I say, counselor, are you, or I'll say, ladies and gentlemen of the jury, maybe some of you are baseball fans, okay? I'm a baseball fan. And so the pitcher and batter are like the prosecution and defense here. They are, they're fighting. They are trying to beat each other. They're the adversaries. This is an adversarial system. They're the adversaries. The judge is the trier of law. The judge is the one who makes sure that they follow the rule book and where the players line up and what pitches are and make sure their uniforms are right and make sure that they are following the rule book to play the game correctly. You guys, the jury, the trier of fact, is the home plate umpire. You get to decide, is this pitch a ball or a strike? You're the one who has to decide that, not me. My job is to help you understand the size of the strike zone. My job is to help you understand the size of the strike zone. And in a self-defense case, the strike zone has both an objective and a subjective component, just like in baseball. In baseball, the home plate is so wide, okay? It's the same width for everyone. It doesn't matter anything else that exists. The home plate is this wide for everybody. So that's an objective standard that everybody gets. However, based on how tall the batter is, the top and bottom of the strike zone is different for everyone. There's a subjective piece here because some people's knees are lower than others. Some are higher. Some people's armpits are higher and lower. So the size of the strike zone vertically changes based on the individual. The size of the strike zone horizontally never changes for anyone. Same in a self-defense case. We have an objective standard that's the same for everyone, and then a subjective standard based on what the defendant, what the person or the person who was acting saw and acted based on. So that changes for them. That's a subjective standard. This is an objective standard. And that's my job to help you understand. So then that way you can make a good decision as to whether this was a ball or a strike. That's my mission. So I'm going to help to understand those technical issues, understand what the standards are, understand what the issues of people doing things. Because sometimes we can ask fish to fly. Sometimes we can ask people and say, well, in that 0.06 seconds, he should have stopped his actions and done something else. You may as well have asked him to sprout wings and fly. He can't make a decision in 0.6 seconds and change his behavior. That's not how human performance works. And we know that from scientific studies. And we can cite those studies. So that leads me to my fourth point, is that you want to actually hire a real expert. You don't want to hire somebody whose last training in anything started in the 20th century. And I'm not saying training from the 20th century isn't any good, but I'm saying in use of force, the last 25 years have been highly significant in terms of getting better understanding of human performance, changing our understanding of who can carry a firearm, right? The right to keep and bear arms, over half the states now are constitutional carry. But the standards of the use of force haven't really changed, other than a few states have abrogated the duty to retreat. The use of force laws have been fairly consistent. So, explaining that to them, having somebody with real expertise, and that real expertise is in understanding human performance, understanding decision-making, understanding memory, understanding how the evidence works in relation to how a human makes decisions, and were those decisions in the moment a product of perception or of guesswork? Did it have any evidence to back it up, or was it pure speculation? Those kinds of things. So when you have all that, then those are the basis by which we can ask a question as to whether this was reasonable or not, and leave that in the hands of the jury. So if you hire somebody who is not and can't actually articulate those things, who can't show that the fact, they can say, well, here's all the data that I used, but they can't show reliable principles and methods other than because I said so, or because that's what I was taught, you got to have a little bit more than that. So that means hiring a real expert in use of force in order to work your case. And there are a number of real experts. I mean, if I was looking I mean, obviously, in America today, the one that probably most people know is Massad Ayoob. Massad has been teaching use of force and been an expert for decades and decades, and he gets in court all the time. Dr. Bill Lewinsky from Force Science, he's in court all the time. And if you go look at Dr. Lewinsky, I swear that man has been admitted in court hundreds of times. And so he does this all the time. Likewise, Von Kleem, who's been on the Active Self-Protection Extra channel. You can see such an incredible expertise he has, not only in police work as a guy who did cop work for a decade, but also has a JD. So he is a fully practicing lawyer, practiced as a JAG lawyer for quite a while, and does all the human performance stuff too. This is why I train so hard to make sure that my information is up to date and make sure that I can help people that I am qualified to do so. So how do we answer a Daubert challenge? The report. The report is the #1 way. That's how we answer the Daubert challenge. So let your expert write a report and make sure that report is high quality and that it goes through the 3 very specific criteria of the Daubert challenge, that it's based on sufficient facts or data, which should be all of the evidence that's been disclosed. It has the testimony is the product of reliable principles and methods that you show. Here's what we did to showcase. Here's how people make decisions. Here's what the defendant had to look at in the moment. Here's how those things worked down and why this was or was not a justified use of deadly force. And then we apply those principles via the methods into the facts at hand to come to a conclusion. If we do that, then we say, Your Honor, this is just to apply these technical issues. We want to explain to the jury how these technical issues and how people actually make decisions that they're not normally going to know. And to do so, we want to use the expert because he's the one who can testify to that. Then that will defeat a Daubert challenge so far every time that I've seen one. So having a great report written by a highly qualified expert who has the training background and experience, who applies good principles, who actually does the legwork to say, hey, here's the studies that I've read, here's the peer-reviewed research we've done, here's the demonstrations that we've made, here's the ways that we can illustrate this concept, so then that way a jury can understand it better and apply that to the facts to make a conclusion that is based on robust data. And if we do that, we should be able to overcome a Daubert challenge, and that's how we've done it. So make sure, hey, you're following the latest, right? So December 1st, 2023, that latest Federal Rules of Evidence 702 is really helpful. Obviously, if we're in state court, we got to go by the latest state one. Most states are following the exact same verbiage, and that's a very good thing. Number 2, that we've done the 3 significant tests that Daubert has, and that we bake those into our report. Experts, hear me. If you're not baking those into your reports, if you're not showing that in your report, and just walking your way through that, you're just leaving your lawyer high and dry. And lawyers, when you see that report, first of all, you should ask for it. First of all, you should be like, hey, I want the report because the report's going to tell me what the Daubert challenge is going to look like. And 2, let's make sure that we've hit all 3 of those standards. So then that way we're good. And then we can show the judge we have a preponderance of the evidence that this is going to help the jury. And if it helps the jury, then we should be able to easily overcome the Daubert challenge. That is how we do it. I hope that helps all of my attorney friends, and I hope it helps all of you who are not attorneys to understand why this stuff ends up costing a boatload of money. Because I can tell you the last 3 cases that I've had just writing the report. Now, I'm not talking about actually looking at the evidence. Once I know all the evidence, once I have all of the discovery digested, writing the report in the last 3 cases took me an average of 10 hours of work. And again, that's once everything is done. And you might go, John, you wrote 25 pages in 10 hours? Yeah, I write really fast and I get after things and put things together really quickly. And some of it, like there's a big chunk of that, a couple of pages, 3-4 pages, that's my background and who I am and why I'm writing the report. That's kind of boilerplate. You can cut and paste that into something else. So it was really more like, honestly, about 15 pages of writing that I actually did, somewhere in that ballpark. That applied directly to the case. And yeah, that takes me about 10 hours to do and do well all by itself. So, and that costs money. And unfortunately, this is another reason why you want to stay out of a deadly use of deadly force if you can, because this kind of stuff gets expensive if we get to this level. But that, friends, is how you answer a Daubert challenge. Hope it helps you.